Good afternoon. I'm very happy to welcome you to this year's Jerome Hall Lecture. Jerome Hall, a faculty member at our school for 30 years, was a legal philosopher and a noted scholar in the area of criminal law and jurisprudence. This lecture series in his name is one of the signature events of our Center for Law, Society, and Culture and brings influential scholars of law and society to our school each year. Previous Jerome Hall lecturers have included Thomas Green, Sandy Levinson, Rachel Moran, and Joseph Raz. Today, it is my great pleasure to welcome Malcom Feeley, the Claire Sanders Clements Dean's Chair Professor of Law at the University of California at Berkeley. Professor Feeley holds a BA in Political Science and English from Austin College, Texas, as well as an MA in Political Science and Sociology of Law and a PhD in Political Science from the University of Minnesota. He taught at New York University and the University of Wisconsin before joining the faculty at Berkeley in 1984, and has held visiting positions at a number of universities in the US and abroad, including Hebrew University, Kobe University, and Princeton. Professor Feeley is a highly decorated scholar of law and society. He has been awarded research fellowships from organizations including the Russell Sage Foundation, the Guggenheim Foundation, the National Institute of Justice, and the National Science Foundation. His books have been recognized with awards including the American Sociology Association's Citation of Merit and the ABA's Silver Gavel Award. He writes primarily in the area of criminal process, addressing issues such as litigation about prison conditions, the judicial process deployed in minor criminal cases, and the role of judicial policymaking in the area of criminal justice. His work provides truly some of the most powerful accounts of how law operates within specific cultural and social contexts. He has been a tremendous influence on his own students, some of whom are now our faculty members, and on an entire generation of law and society scholars. The title of his lecture today is The Unconvincing Case Against Private Prisons. Please join me in welcoming Malcom Feeley.
Thank you. Thank you. Thank you very much, Dean Buxbaum. It's a real pleasure to be here, in part because I see some former students in the audience. Not only somebody from the law school at Berkeley, but somebody from my undergraduate teaching days many years ago with Charlie here. And I don't know, is Ken now Schmidt around? They were on the same seminar that I taught these many years ago. So it was a small. There was a third person in there, Jack Bierman, who's teaching law at Boston. So that wasn't bad for one small undergraduate seminar. And then I see other friends and people whose work I have drawn on over the years. Look, this is a fantastic honor for me to give the Jerome Hall lecture for two reasons. First of all, I read Theft, Law, and Society just about 50 years ago, his great book on legal history. And Ginny, hello, I didn't see. And it has in many ways, it influenced me then, and it continued to influence me in much of my work. Indeed, some of the things I'm talking about today, you could show some linear descent. I'm also impressed because I know some of the people. I know the list of people that have given the Jerome Hall lecture in the past, and there are people I hold in high esteem, particularly my former colleague Rachel Moran, who was here last year talking about our mutual hero, Clark Kerr. So with that, it's with some modesty and trepidation that I begin my talk here. Look, in 2009, the Israeli Supreme Court issued a sweeping decision holding that a private prison about ready to open was unconstitutional, and it prohibited the opening of that prison. In developing its argument, the court developed a state monopoly theory of punishment. It argued essentially that punishment can only be administered and by the state that sentences the person to prison. That is, if you are going to sentence somebody to prison, it is your responsibility and only your responsibility and nobody else's to administer that punishment. So private prisons were impermissible. The court's decisions are anchored in provisions of the Israeli Constitution, such as it is, and those provisions are derived from transports from the German Constitution, dealing with the basic law of dignity and liberty. So. With this, and the decision by the court, I should say, is really more than a constitutional decision anchored in a distinctive Israeli interpretation of those provisions. It is written as a sweeping and broad statement of political theory. It is basically saying no liberal state can operate private prisons because it violates basic principles of liberal legal constitutionalism. With the decision, the issue of human dignity and this particular issue, private prisons, became a global issue. Judy Resnick at Yale and Fred Amon here have picked up and run with it, as have many others, and commented on it. It has become a major issue discussed around the world, as I think it should be. Now, the state monopoly theory set out by the court has also been elaborated on, extended, and formalized by a handful of legal philosophers, most particularly Alon Harel, a legal philosopher in the law faculty at Hebrew University. And as a body, that is the court's long 300-and-something page decision and the several articles by legal philosophers that have amplified and formalized it, these have become the strongest theoretical statements I know of, with which I am familiar, that deal with private prisons. Now, I want to challenge this theory head on. It's a strong theory. One has to pause and reflect. It's not a knee-jerk reaction against private prisons, but it is a thoughtful and sustained analysis that is offered by these several people. And I want to argue that this seemingly impregnable argument that they establish does not establish a convincing case for the state monopoly theory advances. I want to work in the same tradition as the court and the philosophers. I want to take them and their arguments seriously, and I want to interrogate them, and then I want to show that in their own terms that there are too many unacceptable consequences, too many anomalies, too many inconsistencies in the theory to allow it to stand as a defense against or an argument against private prisons. So here's what I want to do today. I want to first summarize and set out the theory against private prisons that is offered by that are offered by the court and by the legal philosophers that is seized on it, and then I want to raise some of those problems that I alluded to a moment ago. I identify four fatal weaknesses in the theory that leads us to reject it, and then I want to ask the question, where do we go? What do we do? Where do we go from there? So first, to outline the state monopoly theory. The long and carefully constructed opinion by Court President Dorit Benish raises and rejects various arguments in favor of prison privatization. And it's a really tour de force opinion that quotes everybody from Thomas Hobbes to Michael Walzer and many people in between. It draws on the history of Anglo-American history, English history particularly, and classical liberal thought and contract theory in developing its argument. And the argument that it comes to is the state must shoulder the responsibility for the administration of punishments that it orders. To quote from the court opinion, it's infelicitous when translated into English, but when the entity responsible for imprisonment is a private corporation motivated by economic considerations of profit or loss, the punishment is inherently greater than the same punishment that would be administered by a public agency. That is it's inherently greater punishment, more severe, more onerous, imposes more indignities on the person being punished if it's a private contractor than if it's a public agency. The conclusion here rests on an elaborate argument about the nature of the modern state. The opinion and then later the philosophers' argument argue that it violates contract theory, liberal contract theory, that it violates our idea of state sovereignty, and that it violates the dignity and liberty of individuals. There's another less obvious feature of the court's opinion, and I want to pull it out now because you see it in the opinion and not necessarily in my brief summary of it. The court repeatedly characterizes the contractual entity as a private corporation motivated by economic considerations. It has private contractors in mind, and it argues that employees for such companies are not able to put concerns for prisons above concerns for their company and their company's concerns for profit. Yet, a careful reading of the opinion, and for that matter, the theorists that follow from it, is that their argument is not so much an argument against private prisons. Their argument is in favor of a state monopoly. Remember, I said earlier, and I quoted earlier, it said the state that imposes a punishment has an obligation to administer or affect that punishment. So while a for-profit company may be a particularly indignant, particularly offensive contracting agent, the court decision rests upon the nations of the state's core responsibility. So again, only the state has the authority to impose punishments, and there can be no substitutes for this. I'm going to come back to that because I think this part of the argument, and this is the core part of the argument, simply and totally fails, and I'll try to convince you of that. Now, Benesch argues that her position is supported by the history of the liberal state and by major political theorists, from Thomas Hobbes to John Locke to Michael Walzer and lots of people in between. Her basic argument is that the social contract, from Hobbes on, argues that the political principle is that the state, through various bodies acting in it, that is, the state is, of course, is a plurality, not an it. The state acting through the various bodies in it is responsible for public security and the enforcement of the criminal law, and this has remained unchanged through all these years. I want to challenge that let me add on here. The political theorists, Alon Harel at Hebrew University and others that have elaborated on this, again make the same point, but they furthermore insist that imprisonment, that is, the prohibition against imprisonment by private entities, applies equally to other forms of criminal law sanctioning, such as probation and shaming, the informal shaming that we see in various ideas of notions of restorative justice. And unlike the court, Harrell and the political theorists do not turn to classic political theorists to explicate their theories of the state, but in the tradition of ordinary language philosophy, they appeal to our intuitions about the state and about the punishment, and then construct a theory around them. What I want to do is I want to take some of their ideas about intuitions about the state and punishment, and again turn them on their head. But again, I want to point out both the theory and the theorists and the court's decision parallel each other very closely, and certainly come to the same ends. Let me give one example of the power of Alon Harrell's theory against private prison. He provides a vivid analogy to the family. He said, in a family, parents stand in a unique, and this captures, I think, the essential argument of both traditions here. In a family, the parent stands in a unique relationship to the children. One manifestation of this unique relationship, he argues, is that parents have a capacity, and are understood to have that capacity, to punish their children in situations that are not criminal and that nobody else has. That is, parents can punish their children in ways and for things that nobody else can. They can punish how much and so on might be debated, but they can punish their children for not doing their homework, for not saying their prayers, for not being polite, for not doing a variety of household things. And the parents, and only the parents, can do that. It would be odd for the parents to delegate that responsibility to somebody else. It just doesn't make sense. So he says, in an odd way, looking at the power of the parents to punish their kids helps us understand what the distinct nature of the family is. Now, Alon goes on to argue that criminal offenders relation to the state is a bit the way children's relationships to their parents are. It's an odd, it's an uncomfortable analysis, but nevertheless it makes a certain sense. It's next to impossible to imagine somebody else other than a parent chastising their kids for not saying their prayers at home, maybe, or not making their bed in the morning, and so on. So that's it. And he summarizes his argument by privatizing the infliction of the sanctions, going back to the state. The state effectively not merely transfers the technical power to execute the sanction, instead it strips itself of the power to make binding determinations concerning the wrongfulness of the act and the appropriateness of the sanction. High power. It strips itself of the power to make binding determinations of the wrongfulness of the act and the appropriateness of the sanction. So it, in effect, diminishes not only the individual, it diminishes the state in a way that undercuts its legitimacy. So in sum, both the monopoly theory put forward by the court and the theory put forward by the philosophers provides a categorical and universal, not a peculiar constitutional provision that is applicable to only one tiny state in the Middle East. That's why I say it's a real challenge, I think, to global constitutional theory, and Fred Amon and others have picked it up and seen that for exactly what it is. Okay, now I want to criticize this theory very briefly. I've outlined it. I haven't done it justice. You can all read the many pages I've written on it, and I can cite the cases for that matter if you want to read them. I've outlined the theory, and now I want to test it on our own intuitions. I just want to see whether this theory makes sense in light of a variety of different situations that are presented as defenses by the people that argue, by the court and by the theorists that argue. But as I interpret it, I come to somewhat different conclusions. So I want to look at the lawyer's history. That's not very good history, is what I mean. In this, the failure to confront contemporary theories of the modern state. In fact, I think the failure to confront Hobbes and Locke as well, but certainly the modern state, the failure to address our own intuitions about prosaic functions of punishment that they ignore, or privatization that they ignore completely, and then the neglect of other state-based forms of punishment. That is, I want to identify 4 issues that that each of which runs counter to or seems to chip away at the at their argument about the state monopoly theory, and then when considered together just seem to utterly reject it. Let's look first at the lawyer's history, and by lawyer's history, I hope I know what you mean. Lawyers are in the business of winning cases, and when they write history or present history, they're usually in the business of telling a historical story that arrives at the conclusion that is best for their client, right? So it seems to me that one of the problems of legal scholarship, even in the academy, is there's a bit of a lawyer's history that is carried over there. At any rate, let's start with the easy prey of lawyer's history that informs the court decision. As noted earlier, the court asserts that the essential feature of the liberal state is, and it goes on to say, and has always been and always should be, is that the state and no other institution exercises the power to administer punishment. Well, one doesn't need to know very much about English legal history and English criminal justice history to know just how utterly foolish and incorrect this. As history, it is total nonsense. When Locke and Hobbes were writing, the state had no administrative capacity, and it was private parties that managed the jails, and even the executioner was paid on a per capita basis, as it were. So it just I mean, throughout history, private contractors have run. Indeed, the father of the modern prison. That is the father of the idea of the modern mass prison for mass incarceration is Jeremy Bentham. And Bentham, you're all familiar with Bentham because of his ideas for panopticon, his design of panopticon. But what's more intriguing to me was Bentham and his brother Samuel were dead set on getting the monopoly contract to run the prisons in England. And they thought they were going to get filthy rich. He even bought land on the banks of the Thames where he wanted to put his factory prison. He was going to make his money by taking the inmates at no cost, maybe if he could get a subsidy fine, build a prison, turn it into a factory, or lease out the convicts and get rich. For 30 years, between 25 and 30 years, he was obsessed with this idea, and it was this that led him to do all his work on revising the criminal code and all these other things that we know about it. But it was a plan to get rich, and his initial idea of the prison was that it would be run by a contractor who could make a substantial living from it. So in sum, wherever one looks at the history of punishment at least in the Anglo-American world, in the English world that the court draws in, one doesn't need to scratch very far to find that private contractors were instrumental. Indeed, I want to argue. Anyway, that's enough for another talk. So let me turn to a second concern. The second concern is this, and it's complicated, and I think the court here too, and Harrell and colleagues, the philosophers, have it wrong. They offer a very, that is, the issue is, can the sovereign state legitimately contract out or delegate one of its responsibilities to a non-state actor? And they review, the court reviews both Hobbes and Locke on this and says no, the social contract delegates responsibility for government to the sovereign. And the sovereign is supposed to exercise it. Now, there is something to this. So they had, and by extension, you might think that they have the concept of a unitary state. I don't quite know what a good term. This is one I coined. It's not in contrast to a federal state, but a unitary state where the state has all responsibilities. Maybe that is implied by what they say, but it's not clear that it does. And furthermore, there's no normative purchase on it. It simply says that the state should do no more and no less what it's contracted to do, and it can't in turn delegate something else that it's been contracted to do. It doesn't mean that there might not be another contract that could change the relationship. But at any rate, they seem to suggest that the state has been delegated the responsibility for it's clearly delegated the responsibility for making the criminal laws, both Hobbes and Locke and others. But it's not even a careful reading. Just a casual reading of these political theorists suggests that reveals that the delegation that they are talking about is to the legislative function, not the executive function. That is, you can't delegate legislative responsibilities to non-state parties. Well, the modern administrative state has long ago abandoned that anyway. But even apart from that, they say nothing about delegating executive functions, and I suggest that the administration of punishment is a quintessential executive rather than legislative function. More generally, the modern state and theories of the modern state have embraced a theories that might be called the disaggregated state. Everywhere we find students of administrative law in the modern state recognizing, acknowledging, tinkering with, and shaping the responsibility, the shared responsibilities between public agencies and private partners, or public agencies in one country and public agencies in another country. That is, the modern state is the disaggregated state, and there's a huge body of literature on that. So to fall back on a theory of a unitary state strikes me as being several hundred years out of date, if in fact not out of date, even given the theories that the original contract theorists proposed. But let me now turn to two other concerns that are sort of more in the bailiwick of the sort of the historical institutional analysis that I do, and I want to look at two things. First, I want to show that the private prisons theory that the theorists and the court has conjured up, the private prison model that they've conjured up, is a caricature. It's not a totally unreasonable caricature, but it's a caricature nonetheless, and that a broader and more capacious look at private prisons will lead us to see a greater variety of institutions, some of which we're likely just to take for granted and yawn about because they're so familiar to us. And then secondly, I want to look at some other institutions that we accept even more instinctively, intuitively, that are regarded as terrific, but nevertheless violate the state monopoly theory as presented. But first, let me look at private prisons. Part of this paper and part of my agenda here is a result of my spending part of last year in Australia, which has the highest proportion of inmates of any country in the world held in private prisons. Up to 20-25% of inmates in Australia are held in private prisons, and in Victoria, New South Wales, those figures have bumped up to 50% at times. So what I want to do here is just very briefly contrast the American experience with privatization with the Australian. for better or worse, and I think it's for worse, when people around the world think about private prisons, they think about American private prisons in the United States. We probably have the most, not the highest proportion, but the most people in private prisons. And our private prisons don't have good histories. They can be rejected, and a great many of them can be rejected on any number of policy grounds. You don't need to come up with a state monopoly theory of privatization to reject them. The United States has a long history of the convict lease system in the South. It has indeed the early prisons on the East Coast in Pennsylvania and New York were built with a model of the factory and the workshop where they were supposed to produce a profit. They were failures from day one. The prisons moving west and on the West Coast often were to be profit-making institutions because the states had little tax base, and so there and certainly the southern prisons and the plantation model after the Civil War in the South, where prisons literally took Parchment Farm, Cummins Farm, literally took over old slave plantations and modeled the post-war plantations on slave or post-war prisons on slave plantations, and continued to return profits. Texas continued to return income to the state well into the 1960s. All of these things are terrible, and of course, so the American history with privatization is colored by that. And indeed, if you think about it, not everywhere, but to some significant extent, the biggest inroads for privatization of prisons and jails in the United States has been in the South, where public administration has been the weakest, and where they've had these long histories, and where crowding has been most acute, and they are often designed to try to shunt off some problems from corrections people because they're overwhelmed with what they have, and if they can shove things off to private contractors, all the better. The Australia experience is a study in contrast. Like the United States, privatization in Australia came when the neoliberal governments assumed power in the wake of Reagan and Thatcher in the United States. Malcolm Fraser government started promoting, and so private prisons were imposed by the government, by the elected officials. The response to the people in the state ministries to privatization was first to resist. They were protecting their turf. And then secondly, they thought, what the hell? We have been battling corrections officials for years to improve training and programming in the prisons, and they have resisted, citing safety and security time and time again. So they said, why don't we use privatization as a mechanism for developing all the good things we want to do? And so they created a wish list of what a good prison would look like. They went to their political masters and said, you ask us to privatize, develop a plan for privatization, and to cut the budget by 10%. We're coming back with a prison program that has more bells and whistles, and it costs 10% more, not 10%, but we're doing a lot more. And they got permission. And so the private prisons in Australia have been the primary vehicles for experimentation and for developing progressive prisons, and they've been watched accordingly. And almost everybody I spoke to during my stay in Australia, and the reams of studies that I read that were carefully comparing private and public prisons, showed that on almost any dimension you could think of, maybe every dimension you could think of, private prisons did better. Among other things, contractors changed in private prisons. These weren't long-term sweetheart contracts. If a prison was not fulfilling its contractual obligations, the contract was pulled or not renewed, and an alternative was and another contractor was found. So what one found there is successful prison programming that is used as a model to induce state public prisons to try to improve them. Now, why does it work in Australia? It works in Australia for one simple reason. It works in Australia because public administration works in Australia. Public service is strong and competent, much stronger and much competent than it is in many states in the United States, particularly the southern states that have turned to privatization in part because their public service was weak. So ironically, privatization may work where it's not needed, but that's what we found. So in some we find some really successful, innovative private prisons. And one would, and the people I know in Australia who have read the court's opinion and read these other things, just hope that the ideas that are articulated by the theories don't take root there. Private prisons, in a sense, are taken for granted in Australia. Okay, that's one area that seems to me that just simply doesn't fit with the broad theory. But there's another one. I want to turn back home. One of the things I routinely ask people who have an instinctive reaction to oppose private prisons in the United States is, what do you think about juvenile facilities? In the United States, somewhere between 30 and 60% of all juveniles in custody are held in private facilities. Yet I do not know of one, and if someone can show me one, I would deeply appreciate it. I do not know of one discussion about privatization and the propriety of privatization that deals with juveniles. There are, of course, lots of studies that talk about private juvenile institutions, but really takes on the issue, are private juvenile facilities acceptable in a way that we do about public prison, and it's simply. Now juvenile facilities, of course, and juveniles are different. Juvenile facilities are different than prison inmates and prisons. Juvenile facilities are minimum security. They're often open institutions. Guards don't carry guns usually. They emphasize education and rehabilitation. They're small. They're cozy and friendly. They're often run sometimes a private contractors or nonprofit institutions, and so on. And in a formal sense, they're not being punished. They're being held for their own good, and they've been judged delinquent and held for their own good. But nevertheless, if you take the theory against private prisons that I've just given, the big concern is you have this vast discretion of private parties that is used against vulnerable people. And all things equal, it strikes me that juveniles are more vulnerable than adults for various and obvious reasons. Yet no one that I know has addressed private prisons. And one of the reasons they don't, I think, is this, is we take private juvenile facilities for granted. Now, there's some terrible scandals, and we know that, and we read about them from time to time, but there are probably as many or more terrible scandals in public facilities. But by and large, we take private juvenile facilities for granted because they probably do as good or a bad job, or can do as good a bad job as public agencies. So I think they're invisible. They're invisible for I think pretty good reasons. Now I want to wind up very quickly with two more exceptions that seem to challenge the theory of privatization, and these strike me as being. I lived in Wisconsin and Minnesota for a while, and one of the things that would happen in Wisconsin and Minnesota is that if a person from St. Paul was convicted of a crime across the St. Croix River in Wisconsin, convicted by Wisconsin courts for a crime in Wisconsin and sentenced by Wisconsin judges, there was some chance that he wouldn't be sent down near Baraboo to serve time, but he would be sent across the St. Croix River to Stillwater, that's just a few miles from St. Paul, where his family lived. One state would convict of a crime and sentence, and another state would administer the sentence. Now, everybody I knew then, and all my intuitions, tell me that despite the state sovereignty theory that is put forward by the opponents of privatization, this is a good thing. This is a pretty good thing. Furthermore, there are variations on that. There are international compacts that allow people to be returned to their home country under certain circumstances to serve their time in facilities where people speak their language and the food is their own and they're near their families. And again, it seems to me that everybody but the Grinch celebrates. These are really good things. But if you think about it, they violate the state sovereignty theory, that only the state that it sentences the state and only the state that sentences must administer the punishment. So when I review these and still other things, what I see is a variety of anomalies, exceptions, inconsistencies that don't fit with the state monopoly theory. Now, maybe you could get rid of that by saying, well, if the offenders sign waivers, they can all bets are off and they can be sent to the. But this strikes me as a fig leaf that even that the theorists against privatization would reject for good reasons. So. My point here is when we wind up is what to conclude. Well, one thing I want to conclude is the argument against private prisons may be powerful and it may sensitize us to real and serious problems, but it has obvious, but it has no real strong purchasing power. It's just a warning. Be careful. These are problems that might happen. It's not compelling. My intuitions, and I suspect your intuitions about if nothing else, juvenile facilities and interstate compacts and so on, is that they make a lot of sense. And to the extent that they do, maybe the theory needs to be curbed and cut down. But my argument is that it probably needs to be rejected. Now, rejecting a categorical argument against private prisons hardly means the embrace of private prisons. Private prisons in a great many places in the United States can be easily rejected or at least viewed highly skeptically for any number of sound policy reasons. And Fred Amon in some pieces has begun to lay out those very nicely. But certainly the best prisons in Australia, the models against which public prisons are, the standard, the gold standard. Now, prisons are terrible institutions, however you look at it. But the best prisons in Australia are the private prisons, and they're the standard against which now public officials are comparing the performance of public prisons. So my point is the picture is mixed, and the answer is: should we privatize? It's very simple, but but still confusing answer. It's all depends. It all depends. We don't have any silver bullets and we don't have any categorical answer. It all depends, and it depends on a variety of factors. One set of factors that it obviously depends on are there not only good standards and good oversight that equal the oversight and the standards held in public facilities, but is there, even more important, I suppose, is there the administrative capacity of the state to oversee that. That is, private prisons, the successful private prisons really depend, so far as I can see, depend on successful, effective public administration. And if you don't have that, you're not likely to have a successful private prison. Now, there's one other thing, and this is the source for this will be a source for my next lecture when I come. Another thing it depends on. One of the things I've found consistently historically is that we think of private contractors as performing the same functions as public agencies, just substituting a private. But what I have found consistently, not all the time, but consistently, is that one of the most interesting features about private contractors is that they are entrepreneurs. And entrepreneurs don't simply provide something, the same product cheaper than the public agencies. They create new products and new demands. And hence, they expand the net of social control. Let me leave you with one thing in advance, and I can talk about 100 of them over lunch or later if you want to. And that is, think of electronic monitoring. Almost everywhere in Australia, England, the United States, wherever I know that electronic monitoring, that is these bracelets now with GPS devices on them, are characterized as alternatives to incarceration. But when I review the literature, and just read it, it's there, almost everybody that looks at them concludes that somewhere between 70 and 95% of the people who have electronic or monitored electronically are people who have had the electronic monitoring devices as add-ons to otherwise straight probation rather than alternatives to prison. That is, for every person that remains out of prison but for the device, 8 or 10. Or for 8 or 10, it's an add-on, and it complicates and enhances social control, and indeed more than social control. If you violate it, then you'll end up in prison for sure. So the big challenge for privatization, it strikes me, is not can it be used effectively. I think it can be, and I've demonstrated some efforts, and I've demonstrated that the state monopoly theory doesn't make sense with respect to juveniles and interstate transfers, but we ought to be wary of privatization because private contractors are entrepreneurs and can generate new forms of punishment, and indeed one sees it again and again and again. And to the extent that that's a problem, it's a real problem. But these are practical problems, not inherent theoretical problems that I began my talk wanting to dispel you of. Thank you very much.
I think there's time for a few questions, if anyone has any for Professor Feeley.
I guess I agree with you that there's no categorical reason based on the social contract as to why you couldn't have private prisons. But I do think there's a pretty good empirical reason based on public choice theory. And the example I would give you, this is my area, the example I would give you is actually based on juvenile detention. Within the last 3 years, I noticed from reading the papers that we had two Pennsylvania judges who were convicted of taking $1 million bribes to send juveniles to juvenile facilities so the facilities could charge the state more. And even though that's kind of, and actually one kid committed suicide being sent to these prisons when he should have been sent to them. And even though that's kind of an extreme example, it does kind of illustrate that when you combine the coercive part of the state with the profit motive, you can get over punishment and over imprisonment. And if people, private contractors are very effective at getting what they want out of state legislators in our system because they can get them donations and things like that. And so if you set up private prisons with incentives to incarcerate people or to put bracelets on them, you're going to get a lot more imprisonment and bracelets because it pays for them to do it.
Well, Ken, that's a really good point, and partly it reinforces my point. That is, it all depends, and this is one of those big depend things. It's not a categorical yes or categorical no. But let me suggest this: it's almost inconceivable to me in the United States that we would want to transform our juvenile system back to entirely public facilities. Imagine, there's no question that the judges in Harrisburg were outrageous. I mean, they had to be, drawn and quartered. But look, many facilities for juveniles have 8 or 10 kids in them. Some have 50, 40. They're small. That was a pretty good size. That was a medium size. I had well over 100, as I remember, bigger. But it's a highly decentralized enterprise that depends on a vast discretion tailor-made to the particular problems of kids. And I can't imagine the state being able to have such flexible, any state, having such flexible, decentralized small units and running it effectively. It just seemed to me the oversight. So in that sense, it seems to me that if we want those smaller, discretionary, organized, family-like settings, we're almost invariably going to have to depend upon private, maybe private nonprofit, but private contractors. Yeah, Fred.
I'm very sympathetic to your argument against the categorical rejection of privatization, but I wonder whether there are some limits within that. For example, what would you, when you're listening to your rendition of those theorists, what would you say about, can you outsource executions?
Well, of course we used to, but no, I wouldn't. I would think we wouldn't want to. Maybe because death is different. I'm not even sure how much I would want to outsource. Even life imprisonment or managing death row. But we ought to get rid of death row, obviously. No, I would think there would be limits. But I think those limits, and some of those limits, many of the limits I'm suggesting are prudential limits rather than categorical limits. That is, if you could, maybe you could develop a categorical theory that says the state shouldn't delegate execution. I mean, I suspect you could pretty easily. But remember what they're saying, the state has to be responsible for all people on probation. Or shaming punishments, these experiments that had their origins here in Indiana with restorative justice, the Mennonite movement, and so on. It strikes me as really good experiments, and to categorically reject those. So, but yeah, there probably are some limits, and I'd have to work out where they are.
Thank you very much. It's really interesting. I guess I might also, along with previous two speakers, challenge your categorical distinction between categorical and prudential. And I guess I'm persuaded by the argument, you didn't develop as much about the dignity argument, and just the practicality of a categorical, ban on private prisons. On the grounds that we imprison so many adults, setting aside the juveniles, which I think you have a more persuasive case. And you can do it much more mindlessly if it just is a line item on a budget that should balance out because we're outsourcing. We don't, as a society, have to take as much responsibility for the number of people we incarcerate. And although maybe you can make some good philosophical arguments why it's not categorical, practically, wouldn't it make sense to for those who govern to take some responsibility in terms of if you're going to imprison all these people, then you have a moral responsibility to follow through and not delegate, and that would be a practical understanding of what you're really doing.
Well, look, I should direct you to Fred. Look, if in fact you delegate, and in the process of delegation, you make the private party, in a sense, a public official that is subject to oversight and the same sort of conditions. But it seems to me that that many of the responsibilities that your concerns that you're raising are taken care of. Now, maybe if people can sweep it under the rug, certainly one of the issues that this state probably experienced, that has taken place in many states, one of the great boons of privatization years ago was the leased purchase system for prisons, so that the state legislature and the state voters didn't need to vote on bond issues for capital expenditures. And so they got, the state legislators created this obligation without having to go to the voters to tell it. So that's kind of a subterfuge. To the extent that they're subterfuges, it's a bad thing. But again, I would hate to use a categorical imperative, as it were, for an instrumental means. I mean, Kant would tell me I'm wrong on that, to do that, I think. And I think it would be wrong. A responsible, look, it's a tough issue. I'm not defending privatization. The private institutions in this country are by and large terrible. You can point to some exceptions, I'm sure. But they're not good things. They sprung up in the South, which as a way of getting problems off the desks of the overburdened corrections officials, and so they haven't been. Now there's some places that run, but our juvenile system runs pretty good. And Australia experience is really eye-opening. They're the best. Everybody, even opponents of private prisons, say they're the best prisons in the country. They're the standard against which we can measure the success of public prisons now. And here's what I think. Here's what I think the central issue about privatization is, and maybe I should have talked about this because this is all part of the big book I'm working. And that is, I think the big issue on privatization is that private contractors are entrepreneurs and are very clever at coming up with new forms of punishment and expanding the net. The single biggest dramatic source of reform in the modern criminal justice system was transportation to North America, transportation of felons to North America in the 18th century. And what happened is slavers in the slave trade, got wind of the crisis of law and order in England and Ireland, got wind of the labor shortage in the area where Charlie used to live, and they would bring felons at no cost to the state to sell them into limited term slavery in the mid-Atlantic states. It dramatically increased the state's capacity to punish. And I think that set in motion the desire to create public law enforcement, public prosecution, expand public prosecution, and create stipendiary magistrates to reform all of a sudden they had a greater capacity to punish than to bring people up through the pipeline. So that's a real concern. But those are pragmatic concerns, not principled concerns. Yeah.
I was going to push you in the other direction. You just alluded to private prosecution. I'm curious, I haven't read the philosophers that you're talking about, but is the theory that the state has to have a monopoly on punishment, does that extend to other parts of the criminal justice system? Does the state also, in principle, have to have a monopoly on investigations and on prosecutions? Hard to square with the long tradition of private prosecution. Certainly we say private investigators and confidential informants. We have people who
Look. In many places, private parties, victims have some limited capacity to prosecute, although the courts look at it disfavorably. But certainly in England, the private prosecution was in a sense nominally private until 1984. It was only nominally, I appreciate, but well into 1836, well into the 19th century, there was private prosecution. Now, one of the things that entrepreneurs did was lawyers created prosecution societies. These were insurance schemes, and they had the incentive to organize the potential victims in a little insurance scheme, and then said, each of you pay a shilling, and if any of you is victimized, the society will pay the full cost. This was entrepreneur lawyers being prosecutors. And very successfully, in the early 19th century, maybe a third of all criminal prosecutions in England were brought by lawyers acting on behalf of. These were, of course, not surprisingly, were merchants on High Street, could easily be organized and pitch in, and were concerned with pilfering and things.
Yeah, I guess my concern is if you don't have this categorical ban on privatization of prisons, if you don't make the discipline function the sole responsibility of the state, if you imagine that as part of the monopoly on violence that a state has, then is the state able to divest itself, if it so chose, of all of its responsibilities? Could you have purely private policing or purely private national defense if it were so inclined?
Yeah. Well, we do. I think we probably spend more for private policing than we do for public policing already in this country. Somebody's told me that, and if not, it's up there close. Look, I guess the answer, again, my answer is, and this may be I'm not an administrative law professor, but the answer for administrative law would be it all depends. You got to structure it. The modern administrative state is complex, and so we're going to be making all sorts of hard choices, and there's going to be a line that we're going to overstep at some point if we're not careful. But it's a mess, and we can't draw too many clean lines, and that would be my answer. And so do we like a mercenary army? No, I'm back. I'm from the era when we were out protesting the draft, but I certainly didn't. I wasn't protesting the draft. I was protesting where the poor guys that were drafted went. I like the idea of a draft. I wish it had come back. I think we've lost something terribly important in the absence of it. But do I think mercenary armies are good? I don't even like American army, and it's a public army, but it's a mercenary for all practical purposes. So the answer is modern life doesn't lend itself to really neat, hard lines. But yes or no? I'm sorry, Dan.
I'm sorry.
Oh, I'm sorry.
Can I
You should go ahead. You should go ahead.
But I want to say that there is a reception starting now up in the faculty lounge.
There's a class there.
And please, I hope, I saw there were a couple more men who can come and join Professor Feeley up there. And please thank him one more time.